I'm Jaclyn Robertson with JR Law Group, and welcome to Family Law Friday. Last week we talked about the first steps and what it takes to get your divorce case initiated. And this week we're going to talk about a basic roadmap from the time your divorce petition is filed to the time that you're actually divorced. Now, of course, there's no set timeline, but the general outlook is that after your divorce has been filed and a counter-answer has been filed in response, there is then a mandatory requirement that the parties attend mediation. So mediation has been a really effective tool in bringing the parties together with their attorney and a chosen third-party mediator in an attempt to resolve all of the issues in dispute in your divorce. This has been a very effective tool, and a lot of cases can settle through this medium. So if you go to mediation and are successful in resolving all of your issues, from mediation there will be drafted and filed a settlement agreement. So once the settlement agreement is filed, your attorney can then assist in drafting the final documents, including your divorce decree. And once that is filed and signed by the judge, that means you're divorced. So the process can, even if there are initial issues in dispute, the process can be fairly straightforward. Now, between the time of when your divorce case starts and to when you attend mediation, there will be required a process of exchanging financial information between the parties. So the initial discovery phase, the biggest piece or component will be the financial declaration. This is a state-issued document. It's 10 pages, and it's something that all parties going through divorce must complete. Now, the document will be a place where you will outline what your income is, your assets, your debts, what your expenses are, and all of your marital estate will be looked at and accounted for in this document. So this is an important piece because it helps the parties exchange information in anticipation of mediation. So again, you do the additional disclosures, go to mediation, and then it can be wrapped up by getting the final documents filed. Now, if this is a case involving children, an additional step that parties will be required to take is to complete two classes. It's a divorce orientation and a divorce education class. That's something that the parties must complete before your divorce can be finalized. Similarly, or alternatively, if you are unsuccessful at resolving the issues in mediation, then from there the case will branch out and there could be some additional information exchanged or sought for by either party, such as additional, in the cases where there's a feeling that they don't have the full piece of the marital estate or the financial information, then there can be some tools used such as subpoenas, additional discovery requests through interrogatories or requests for documents. If this is a case where alimony is an issue, there could be a motion for a vocational assessment, which means the employability of one of the parties will be looked at, or both. If this is a case where the custody remains in dispute, then the next step after mediation would generally be looking at a custody evaluation. And that is where a third party, qualified third party, will come in and make an evaluation as to what the custody arrangement should be. So if settlement fails at mediation, the parties can sometimes give it a second try and settle. Otherwise, you'll be looking at these different discovery measures and or motions, and then ultimately your case will be certified for trial and brought before the judge. Now, there will be a pretrial conference, settlement conference, and different times that you will go to court before trial. And again, this is just another effort to bring the parties together and try to resolve the issues and or certify what still needs to be resolved before the judge. And at that point, if your case goes to trial, this will be a situation where you will testify, the other party will testify, there may be some experts involved, etc. But your full case will be presented to the court, and at that point, the judge will make a decision. The issues will be resolved then, and from the trial, the final documents will be submitted, your divorce decree from the orders of the court, and once that is signed, then at that point, you are divorced. So back to the beginning, as to after your divorce petition is filed and before mediation, even before initial disclosures are exchanged, sometimes there are some acute issues that need to be addressed. So there is a tool called a motion for temporary orders. Temporary orders, what are they? And how do you know if you need them? That's something I'm going to address next week. So follow me on Instagram at JR Law Group, and if you'd like to schedule a consultation, go to my website at jrlawgroup.com. Otherwise, I'll see you next week.